The Copyright Act of 1987 for Malaysia set up the copyright in works and other material, for example, sound recording and video filming, and furthermore portrays the insurance or rights that might be accessible to any individual who qualifies as a performer. Who is a performer? According to Section 3 of the Copyright Act 1987, a performer is described as an actor, singer, musician, dancer, or any person who acts, sings, delivers, declaims, plays in, interprets, or otherwise performs a performance. The shows of the performance, vocalists, and artists are a fundamental piece of creative procedure in introducing to the general population. Since the very first performance recording in sound and images, it has been acknowledged that entertainers ought to have rights over those recordings and a share of the profits resulting from the commercialization of the performance. Why do performers have rights? Performers' rights are of paramount importance as they give the privilege of suing for breaching the ethical right of the performer where there is unapproved misuse of the performance. Performers' rights in Malaysia. Performers' rights in Malaysia is mostly governed by the Copyright Act 1987 under different sections. First of all, one needs to satisfy all the criteria of Section 10A to be able to qualify for protection for a performer. The requirements for a performer are a citizen or permanent resident of Malaysia, or not a citizen or permanent resident of Malaysia, but whose performance takes place in Malaysia, is incorporated in sound recording that are protected under this act, or has not been fixed in the sound recording but is included in a broadcasting qualifying for protection under this act. Performers' right will be applicable in events stated in Section 16A subsection 1. Section 16A subsection 1 is nature of performers' right, and it states performers' right shall be the exclusive right to control in Malaysia. Firstly, the communication to the public of a performance, except where the performance used in such communication it is itself a live broadcast performance. The fixation of an unfixed performance, the reproduction of the fixation of a performance, the first distribution to the public of a fixation or of a performance or copies, therefore through for sale, or other transfers of ownership, and the commercial rental to the public of a fixation of a performance or copies, therefore irrespective of the owners of the copy rented. The law in Malaysia concerning remunerating performers is stated in Section 16B subsection 1, where a sound recording is published for commercial purposes or a reproduction such recording is publicly performed or used directly for broadcast or other communication to the public, an equitable remuneration for the performance shall be payable to the performer by the user of the sound recording. Also, there's a section that says the duration of an equitable remuneration, which is Section 23B of the Copyright Act 1987. As the copyright licensing performers' right also have a limited duration of the protecting right. Rights in a performance which subsist under this act shall continue to subsist until expiry period of 50 years computed from the beginning of the calendar year next following the year in which the performance was given or was fixed in a sound recording. Moral rights of performer. Section 25A subsection 1 of the Copyright Act 1987. A performer shall, as regard his performance or performance fixed in a phonogram, have the right, firstly, to claim to be identified as the performer of his performance, except where omission is dictated. Secondly, to object to any distortion, mutilation, or other modification of his performance that would be prejudicial to his reputation.
In Malaysia, there are few performances that are protected under the Copyright Act 1987, which includes literary work, musical work, artistic work, films, sound recording, and broadcast. The term literary work is defined under Section 3 of the Copyright Act to include works such as novels, stories, books, pamphlets, manuscript, poetic works, plays, dramas, and many more. However, it does not include official text of the government or statutory bodies of a legislative or regulatory nature or judicial decision. With regard to whether there is a need to prove that such work must be literary in character, this has been resolved by the Federal Court in Lau Fun Seng and Government of Malaysia. The court in this case adopted the test in University of London Press Limited and University Tutorial Press Limited, whereby the word literal work covers work which is expressed in writing or printing, irrespective of the question whereby the quality or style is high. In this case, it was held that Peterson J. decided that the case set by the examiners are literary work within the meaning of the Act. As for musical work, it is defined under Section 3 as to means any musical work and includes work of composed musical accompaniment. Music work is protected under Section 7, subsection B of the Act, which the definition would appear to include both music and any accompanying work such as lyrics or words or any actions. Often when a song is copied, the issue would be whether both literal and musical work are copied. An important case on this point is Craig and Hill and Run Music Publishing Limited, where the principal in Designers Guild Limited and Russell Williams Textile Limited will apply respect to substantial copy. As in the case of literal work, artistic works are broadly defined to include a variety of items, not with all which are artistic work in an aesthetic sense. Artistic work is defined under Section 3 of the Act to mean graphic works, photographic, sculptural, collage, and many more. It further defines to include any painting, drawings, diagram, maps, plan and engraving, woodcut, or similar works. Section 7 subsection 2 provides that works shall be protected irrespective of their quality and the purpose for which they are created. In the case of Pecco Wilson Operation Limited and others, and Lina Text Process Rubber Berhad, the High Court interpreted Section 7 subsection 2 as in relation to artistic works that all artistic works were protected regardless of their quality, meaning that such work need not possess any artistic quality. Consequently, it is arguable that all artistic works, and not all those so qualified in the definition, are protected regardless of the artistic quality. A film, however, is defined as a fixation of a sequence of visual images on a material which, with or without the assistance of any contrivance, is capable of being shown as a moving picture or being recorded on any other material so that it could be shown. To be within the definition, the work must have three characteristics, that is, firstly, it must have a sequence of visual images, secondly, these images are fixated on the material, and third, they are capable of being shown as a moving picture. The sounds of embodied in the soundtrack associated with the film are also part of the film. According to Abdul Wahab J. in Polygram Recorded Limited, 11 others, and Asia Amusement Malaysia Sendirian Berhad, he quoted that so long as sounds and images are recorded together on any media, whether the common films, videotape, or disc, it is caught by the definition of film. In this case, it was held that a music or karaoke videogram was a film within the meaning of the Copyright Act 1987. Insofar as videotapes are concerned, any doubts that recording of the nature would fall within the definition of film were dispelled by the Supreme Court in the case of Fu Lok Ying and others and Television Broadcast Limited and others. There in the case, it was held that the defendant had copyright of the film in Malaysia as the qualification status was independent of the qualification of publication. Furthermore, as a case of sound recording, the definition by its reference to material or any description, whether translucent or not, is meant to encompass any material forms or format upon which this image may be fixed, such as cassette tapes, laserdisc, video compact disc, and digital versatile disc. Material may also cover chips or integrated circuits upon which video games are encoded or transposed. A sound recording is a fixation of sequence of sound capable of being perceived orally or being reproduced by any means. The definition of sound recording does not include a soundtrack associated with a film. Instead, the soundtrack is considered to be part of the film. In Malaysia, the Copyright Act 1987 does not expressly deal with the effect of synchronization or incorporation of any existing soundtrack into a soundtrack of a film on the right of the copyright of the soundtrack or underlying copyright work. However, provisions are made with regards to the incorporation of any literary, musical, or artistic work where the film is broadcast. Last but not least, broadcast. Broadcast is defined as transmitting by wire or wireless means of visual images, sounds, or other information which is capable of being lawfully received by members of the public or is transmitting for presentation to members of the public, includes the transmission of encrypting signals where the means of decrypting are provided to the public by broadcasting service or which its consent. The term is, however, defined as any service of radio or television broadcast operating under the general direction and control of or under license by the government in any part of Malaysia.
I'm Mohana Priya here, and I would like to further explain about the qualification of performance right. A performer has an exclusive right to control in Malaysia. According to Section 10A Sub A Copyright Act 1987, a performer's right applicable when the performer is a citizen or a permanent resident of Malaysia. If at all the performer doesn't fit in Section 10A Sub A, Section 10A Sub B covers for the non-citizens or permanent resident of Malaysia. Thus, the performance should be taken place in Malaysia. Incorporated in sound recording that are protected under the Act and has not been fixed in a sound recording, but it is included in a broadcast qualifying for protection. Under this Act, the work other than the published edition is made in Malaysia, or the other work sound recordings, broadcasting and published edition is made in an Berne Convention on member country. Berne Convention on formerly known as the International Convention for the Protection of Literary and Artistic Work. Moreover, when the performance is involved number of persons, only those who are citizens or permanent resident of Malaysia are entitled to rights in their part of their performance. Nextly, I would like to explain about the duration of protection under performance right. According to Section 23A, the exclusive right of performance subsists until the expiry of a period of 50 years, computed from the beginning of the calendar next year following the which the live performance was given. On the next point, I would like to explain the infringement of performance right. Copyright is infringed by any person who does or causes any other person to do without the license of the owner of the copyright, an act that is controlled by the copyright under the Section 36 Sub 1. In the case of Magna Enterprise Sdn Bhd and Su Lik Hook, the application of the Section 36 Sub 1 and Section 13 Sub 1 was relied on, and it was held that for the direct infringement, it must be established with three elements. There is sufficient objective similarity between the original work and the infringing copy. There is a causal connection between the original work and the infringing copy, and what has been infringed must be constitute a substantial part of the original work. The High Court determined that the issue of whether the actual copying must be proved and whether substantial similarity is sufficient in the case of Magna. The court held that there could be infringement even if there is an imitation that is not an exact replica of the works. It does not matter whether the size of the copy has been increased or reduced, or whether the whole or part of the original was copied. Under defenses of performance right, every general rule there will be an exception. Thus, in performance right, the exception rule would fall under Section 16A Sub 3, which the rights granted under the Section 16A Sub 1. The exceptions refers to the direct recording of live performance or to the indirect recording that is a recording made for a broadcast or rebroadcast of live performance. The exception do not refers to use of copies made from the sound recording of film of the live performance, and it can be found in section 13 sub 2. On the other hand, the performance has no right to control direct, indirect sound or indirect film or even live performance was made for the purpose of scientific research, reporting news or current affairs. It also defends the person who makes the direct and indirect copy reasonably believed due to a fraudulent or innocent misrepresentation made to the person that the performance has authorized the making of the recording by the person.
Hello, my name is Muhammad Gamal and I will be talking about exclusive licensing of performers' rights. Licensing has been defined in Section 3 of the Copyright Act 1987, which means a lawfully granted license in writing permitting the doing of an act controlled by copyright. Performers are given an exclusive right to control under the copyright law. Legal rights that are given to them includes the rights to enforce their copyrighted works in cases of infringement either by civil or criminal actions. In terms of criminal prosecutions, it is conducted by the Enforcement Division of Ministry of Domestic Trade, Cooperative and Consumerism, MTDCC, or Royal Malaysian Police. Licensing body or collective management organization is an agency authorized by the copyright right holder to do collections of royalties on behalf of them. Collection of royalty is derived from the use of copyright works by users in commercial sectors. It is mandatory for any agency to be declared as a licensing body by the copyright controller, shortly MYIPO, before the collection is be made. All the collections will be distributed to the members after deduction of certain administrative costs. The official portal provides samples of the application for the agencies to fill up in order for it to be the licensing body of performers. Currently, there are 4 licensing bodies that had been declared to perform collection on royalty in relation to the music industry, which follows as 1. Music Authors Copyright Protection Bureau, shortly MACP, representing composer and lyrics, declared on 28 September 2012. 2. Public Performance Malaysia Sendirian Berhad, in short PPM, representing recording companies, declared on 5th of March 2013. Thirdly, Recording Performers Malaysia Berhad, RPM, representing singers and musicians of sound recording, declared on 6th of March 2013. Lastly and fourth, Performers' Rights and Interest Society Malaysia Berhad, in short PRISM, representing singers and musicians of sound recording, declared on 1st of July 2013. However, in some instances, the licensing bodies will not be able to collect any fees in regards to recordings of performers. This was illustrated in the case of PRISM Berhad versus Misat Broadcast Network System Sendirian Berhad, in which the defendant Astro used some sounds recordings of performers who was represented by the plaintiff PRISM. PRISM was the licensing body for the performers of some recordings. However, the court held that the performers cannot claim license fees from the defendant for the defendant's use of their work. Thus, the performers could not assign any right to be claimed for licensing fees regarding the defendant's use to the plaintiff. This was because the defendant's use of the works did not involve live performance under Section 16A and under Section 3 of Copyright Act. A performance is defined to be one which is given live by one or more persons in Malaysia, whether in the presence of an audience or otherwise. Further, licenses under Section 3 of the Copyright Act refer to copyright only, not equitable remuneration right, and thus performers cannot grant a license under Section 3 of Copyright Act, as this is only for copyright. However, in Obiter, the court opined that if the Copyright Tribunal had decided on the quantum of equitable remuneration payable by the defendant to performers for the defendant use of the work, A. The equitable remuneration right could be assigned by the performers to the plaintiff under Section 4, Subsection 3 of Civil Law Act 1956, or by way of equity. This is notwithstanding the fact that Copyright Act is silent on assignment of equitable remuneration, and B. If there was no assignment of the equitable remuneration right to the plaintiff would have no right to commence the present action in the plaintiff's own name. In other words, a licensee or license holder cannot institute an action on behalf of the licensor or rights owner. Thank you.
So, now we will move to the international aspect, as we can say that the establishment of the performance rights internationally were born by several treaties in order to protect and grant performance right of copyrights under international legal framework, as in the following agreements: the Rome Convention, which only provides a protection of 20 years from the first performance or from the first time it was recorded as a phonogram. Secondly, the trade-related aspects of intellectual property rights, 1994, and the WIPO Performance and Phonogram Treaty, which was signed by the World Intellectual Property Organization to give the performance extra right protections, and according to Article 18 and 19, that there will be no any overlapping between this agreement and the other treaties. Both protect the performers' rights for 50 years. Also, the Beijing Treaty on Audiovisual Performances, which adopted the same period of protection from the end of the year of the performance. A broader understanding of the international concept of performers' right is the American concept. It's a good example to be discussed because the United States is the only developed country that didn't join the Rome Convention by then. Thus, the Americans' performers' rights used in the past not to be protected. As a result of that, the federal copyright law didn't cover performers' right, as in the case of Whitman, where the court held that the performer, after selling his record, has no right. However, the Sound Recording Act 1971 protected their rights in their recorded performance, but with no rights if their works was broadcasted by radio station. And in 1978, the law became more liberal by protecting audio recordings which were transmitted digitally. Nowadays, the performers' rights are protected under state and federal legal theories. Generally, they are covered under the Federal Copyright Statute, which will consider a work copyrightable only when it's formed in a tangible form. However, California is the only state that do not has the condition of tangible form. Under Section 43, Subsection A of the Lanham Act, which is immune because it's a federal statute, and the significance of this statute is noticeable in the case of Charlie Rich, who was a singer, whose sound recording were reused, and by relying at that section 43, Subsection A, he succeeded in his case. Although state common law copyright do exist as theory, it's not applied in any way, and because the three previous sources were very poor doctrines, they look to be represented by the liberal union, who have been weak and could not offer better rights for the performers. The copyright statute regarding performers' rights is very liberal in defining copyrightable works, which are sound recordings, audiovisual works, films, and at once the performances are in a tangible form, they will be protected under copyright statute. Moreover, when the performances are part of the original authorship, then the sound recordings are copyrightable. On the other hand, the Malaysian aspect has obligations to the trade-related aspects of intellectual property rights agreement, and according to the following articles, Article 14 that makes the state to provide performers with the rights to hold certain acts without their consent. Furthermore, Article 14, Section 5, that the protection shall be at least to the end of a period of 50 years, and that Malaysia is not a member of the Web Performance and Phonograms Treaty. Finally, Article 5, Section 1, that the performers' rights ought to be given moral rights during their life, oral performance, or according to Section 25, Subsection A of the Copyright Act 1987, on their performances fixed in phonograms.
Do you think the performance right should be a distinct form of copyright? In my opinion, yes, it should be distinguished because to constantly balance. However, it has become a challenge to maintain this balance in the face of technology, which has opened up new platforms for the creation, exploitation, and distribution of new as well as existing copyright works. Recording technologies have enabled music composers and music studios to explore new opportunities for creation and distribution. Digital process technology has resulted in the development of convention content such as movies, music, and other creative works. The internet development in compression technique, peer-to-peer technology, increased capacity of storage device, and bigger bandwidth have made possible easier and speedier distribution and transmission of such content worldwide. As in the case of Pris Berhad and Miasat Broadcast Network System Sdn Berhad, the performance right distinguished from copyright.
In my opinion, it should be distinct under copyrights, as not only it will protect the work of the owner but also anyone who perform or reproduce the owner's work in public. Not to mention, it will also prevent anyone from copyright infringement. In the 21st century, technology is growing rapidly. People depend on it to get access into doors of information and opportunities. As information now is on our fingertips due to the growth of technology, intellectual property has become unsecured and unprotected. Laws are enacted to provide some protections to the owner of the intellectual property. This is the owner of the intellectual property is given certain rights under the law as the means of protection. One of the rights given to the owner is copyright. The protection is conferred to encourage innovation and ensure confidence of the innovators that their ideas will not be stolen by the others. The rights also will be able to promote public welfare. Without those rights, free riders can appropriate their value created by innovators and thereby undermine the incentive to innovate through piracy, internet fraud, and making scams. As illustrated in the case of Rock Records Malaysia Sdn Berhad and Audio One Entertainment Sdn Berhad, clearly illustrates the sound recording is protected under copyrights 1987. Rock Records Malaysia Sdn Berhad recorded the sound of an artist, thus Rock Records Malaysia Sdn Berhad becomes the owner of the copyrights. Rock Records granted a license to the defendant to produce sound recording in the Laserdisc format. The defendant, however, extended the license to produce sound recording in the karaoke video CD format. The court held that the defendant has no right to produce sound recording in the karaoke video CD format because the act amounts to infringement of copyrights.